so American Constitution Society is interested in promoting the progressive values of the Constitution. Similar to the Federalist Society, we're interested in bringing together like-minded students, speakers to discuss those values, discuss those ideas, and that's pretty much it. So regardless of kind of which side you guys identify with, thanks for being here. It's cool to be able to collaborate with the Federalist Society on stuff like this. I think this will be an interesting discussion.
Well said. So today we have with us Professor Seth Chandler and Professor Josh Blackman here to talk to us about Amy Coney Barrett's confirmation and what it could mean for the future of the Supreme Court. Their conversation will be moderated by Professor Johnny Buckles. Professor Blackman is Professor of Law at the South Texas College of Law in Houston, who specializes in constitutional law, the United States Supreme Court, and the intersection of law and technology. Professor Blackman is the author of 3 books: Unprecedented, The Constitutional Challenge to Obamacare; Unraveled, Obamacare, Religious Liberty, and Executive Power; and An Introduction to Constitutional Law, 100 Supreme Court Cases Everyone Should Know. Professor Buckles is a Mike and Teresa Baker College Professor of Law at the University of Houston Law Center, who specializes in tax law at the intersection of constitutional law and theology. Among his legal works in law and religion, one relates to the nomination process and the relevance of the religious perspectives of nominees. Unashamed of the Gospel of Jesus Christ, on Public Policy and Public Service by Evangelicals, published in the Harvard Journal of Law and Public Policy. Professor Chandler is a Law Foundation Professor of Law at the University of Houston Law Center, who specializes in insurance law and the application of mathematics and computer science to law. His upcoming works include The Network Structure of the Law, a monograph combining network... Oh, sorry?
This is an old bio. All right, go ahead.
This is an old bio. Sorry, I got it from your CV.
They just blamed on you, Seth. Smart.
So it's a monograph combining network theory and Mathematica code to analyze various legal works, including the entire corpus of Supreme Court jurisprudence. So since I assume it's out now, everyone should look into it.
Good save.
Thank you. Without further ado, Professor Buckles, if you would like to begin.
Thank you, Mitchell. So first, I would like to thank both groups for doing this, the ACS as well as FedSoc. I appreciate the opportunity you're providing, both for me and for our esteemed professors on the panel. And thanks to them as well, Professor Blackman and Professor Chandler, for making yourself available to this. And then also, I want to thank every student on the line. This is pretty impressive that over the lunch hour, we've got this many of you who are interested in this. It speaks well of you. I know some of you from here, don't know everybody that's on the call, but thanks to you for participating on this. I do think it's an important panel discussion, and it's great to have the interest of the law students on the Zoom. So I think the way that I will probably do it is I will try to remember where I am in the rotation and start with one of the professors, and then the next time for another question, start with the other one. And then also just by way of format, if each professor could try to focus your initial responses to the questions to probably 3 or 4 minutes each, and then if I have any follow-up for you, a brief follow-up with that. I think we have to cut off at 10 before the hour at the absolute latest, and I'll kind of see how the discussion is going, students on the call, to see whether it makes sense to allow anyone to ask a question and have a brief Q&A at the end. It may be that the professors are just so full of insight and have so much to say that we'll need to just carry up right to around our cutoff time and then say goodbye. So I think Professor Chandler, since Professor Blackman is on the faculty of a school that we are not in, I think I will extend the courtesy of directing the question.
People confuse the name of our schools sometimes, so it might help.
So let's start with a very basic question that has occupied the headline some, the judicial philosophy of originalism. And so, Professor Blackman, what I'd like you to do, just to begin our discussion, if you would you describe what you understand Justice Barrett's judicial philosophy of originalism to be? And then let's just also say, is there anything about her particular brand of originalism that you think is noteworthy in the view of other justices that subscribe to originalism on the court?
Okay, thank you very much to Johnny and Seth, both old friends, and I'm happy to be here. Originalism is not a complicated idea. It's a concept that everyone understands implicitly. If you and I reach an agreement and there are words in that contract and we want to know what those words mean, we would use different tools to figure out what those words mean. Dictionaries, perhaps other legal treatises, different sources to help inform the meaning of a text. But a problem arises when we're dealing with an older text because the meaning of language drifts or changes over the years. At the most basic level, originalism asks, can we determine the original meaning of the text? How would a reasonable observer in the 1780s have understood the various provisions of the Constitution? It's not a controversial idea in the abstract. It only becomes controversial when you apply it to specific questions. Originalism might support some parts of the Supreme Court's doctrine, and it might not support other parts of the Supreme Court's doctrine. Justice Barrett is a passionate, full-throated originalist. She makes no hesitation about it. She has said the jurisprudence of Justice Scalia is her jurisprudence. Professor Buckles asks, are there any ways in which Justice Barrett may approach originalism differently? I think one possible avenue has to do with the relationship between precedent and originalism. And this is an issue that has given originalists, some difficulty for some time. We can be candid and say that much of the Supreme Court's cases really had nothing to do with text and history. They were sort of just made up from whole cloth. But those are precedents that people tend to like. And courts are very hesitant to reverse precedents in which those people rely upon. So in the Supreme Court, you have different wings. You have Justice Thomas, for example, who is a committed originalist who sees very little role for stare decisis, a little role for standing by precedent. He would overrule whatever case you bring him in the constitutional context. Seth is laughing. I think I'm only slightly exaggerating. And then you have Justice Scalia, who would often say he was a faint-hearted originalist, or he would say, I'm an originalist but not a nut, is how he put it. And I think Scalia had a stronger preference to standing by some precedents, perhaps not all precedents. And then you have, the newer originalists. You have Justices Gorsuch and Kavanaugh, who haven't really showed us where they are on the stare decisis spectrum. I think Kavanaugh is more willing to stand by precedent, and Gorsuch is more willing to throw it to the wind. I don't know where Justice Barrett falls. If I had to guess, she's closer to the Scalia wing than the Thomas wing. But I'm very excited to see what she does. She was a very a careful scholar. I think she'll approach these issues with the humility that she brings to everything she does. And if she decides that there's some precedent that warrants reversal, I think she will struggle with it and not just reflexively go after it.
Thank you. Professor Chandler, just focusing on the judicial philosophy, is there anything that you would like to add or qualify with respect in general to Justice Barrett's likely approach to originalism, or how you see her fitting on the court with other justices' perspectives on originalism? And feel free, if you would like to add the relationship to handling the precedent, as Professor Blackman did, feel free to do that as well.
Right. So I don't disagree with really much of what Professor Blackman said in his description of originalism. And the thing is, really, at some level, almost all the justices are originalists. That is, I don't believe there's anyone on the court who would say that we simply disregard the words of the Constitution or the intentions of those either in the public or possibly amongst the founders who were thinking about those issues at the time. The problem is, and here I agree, we have an old document and a new world. And so it is often, at least in many people's opinions, indeterminate what the public meaning of the right to bear arms is, or the establishment of religion is, or privileges and immunities or equal protection in a world that's very different from the ones that the framers lived in. And so I think everyone agrees that there is this zone of construction in which you try to do the best you can with the text, but at some point, whether you admit it or not, your own values infiltrate. And so, to some extent, I think, Professor Barrett and Justice Barrett, followed the party line, the easy line with respect to originalism, claiming that you would be faithful to the Constitution. It's hard to imagine someone saying they wouldn't be. But the question is, what happens when push comes to shove? And I don't think interpretation is a mechanical process. If it were a mechanical process, the justices, they're all very smart, would almost always agree. Professor Blackman's fantasy SCOTUS wouldn't exist because you wouldn't be able to predict what the justices were going to be able to do on a consistent basis. So we certainly have an originalist justice. Her testimony at the hearing suggested that she was going to pay very careful attention to history and that she was going to respect at least some precedent, but she left herself an awful lot of wiggle room thanks to the inept questioning of most of the senators, or the lack of questioning from the senators, who instead decided that this would be a good opportunity to pontificate.
Okay, so before we go to specific areas, I want to follow up. I'll follow up with Professor Chandler and then ask Professor Blackman to follow up with Professor Chandler's response. There was something interesting, Professor Chandler, in the way that you framed originalism. You're saying at some level everyone is, and you referred to both a zone of construction and then you referred to indeterminacy. But there's something in your answer that I would like you to speak to. Are you saying that the values of the justices are going to be relevant only when there is indeterminacy, or are you saying that in this zone of construction, there are some areas, besides just number of senators or something, where we can look to the history and find determinacy, and in those situations, that it's perfectly fine to accept the agreed upon original understanding? I'm not quite sure what your perspective on that is. So if you could,
right. So I guess my view is those cases where the Constitution is clear seldom get to the Supreme Court. They're resolved at a district court level, an appellate court level. Usually the cases that get to the Supreme Court are hard. Not always, but at least the Constitution cases are difficult. And you have the threshold question as to whether the Constitution is ambiguous, and then when you determine that it is ambiguous, what do you do? It's not all that different, and I thought Professor Blackman's point about relating it to contract law was useful. It's not that dissimilar from what is often the case in evaluating the parole evidence rule. But, if it were a mechanical process, people wouldn't care whether it was Amy Coney Barrett who was on the Supreme Court, or Randy Barnett, or Larry Solomon, or Leslie Griffin, pick your law professor. It's because we believe that there is this zone of ambiguity in which one's values cannot help but play a role, that she, among many qualified individuals, was selected for the position. So I guess my view is that zone of construction is in fact in many Supreme Court cases, pretty large.
Okay, so Professor Blackman, what about you? Do you think it's an accurate vision of the way constitutional adjudication works to think that, well, by the time something gets to the Supreme Court, an originalist probing of the text is probably not going to get us anywhere and it has to be resolved some other way? Or do you think there's a more room for substantive originalist inquiry by the time a case gets to the Supreme Court?
Well, let me give an example that I know Seth will appreciate because he's a numbers guy. The Constitution says the president must be 35 years old, right? And that's often held up as an example of a bright line rule that doesn't require construction. Is that 35 years on the Julian calendar or the Gregorian calendar? Because those are not the same thing. There was actually some cases in which the year on a contract was listed and it was unclear which calendar you're using. Today we only use one calendar, right? But in the 1700s, there were different calendars. So how do we know which calendar to use? Well, we look at the calendars that were in common use at the time. I use this example to sort of just as a gut check that all law is about interpretation. And there are some neutral principles that can be used to handle what seems like an obvious case, but really can be an issue of some dispute.
Okay.
And I do think the construction zone that Seth describes is a fair point, and justices do bring certain values to get there. But I want to take a step back and recognize here we are in the year 2020. We're talking about how to do originalism properly. We have 4 and maybe 5 originalist justices. 30 years ago, that would have been unheard of, right? 30 years ago, no one was talking about originalism. It was a crank theory, right? Maybe at Justice Hugo Black and maybe a couple others, but this wasn't something that was talked about. And I think one of the virtues or perhaps the successes of Justice Scalia is to sort of bring this discussion to the mainstream. I am happy to debate all day about how big the construction zone is. That's if you watch baseball, right, you see there's a strike zone they put behind the umpire, right, to see, how big is the strike zone. I'm happy to have that debate. I think that's a much more fruitful debate than simply arguing, straight up, how should we just conform the Constitution to contemporary values, right, the living model. I'm happy to have this debate any day. Well,
thank you. Today we won't have that debate, though, because we got to focus some more on okay. Justice Barrett. So this time I'll start with Professor Chandler. You started to illustrate the relevance of this in terms of some specific issues, Professor Chandler. And, there are all kinds of issues that come to mind that people have been talking about. I'm not going to try to direct the discussion of the panelists on any particular issue. I'm going to let you have more latitude here, but just to kind of name a few that are in the forefront of a number of minds: restrictions on abortion, gun control legislation, religious freedom, executive power. These are all issues that people are concerned about. And I'm wondering if you have any views about how Justice Barrett's judicial philosophy are likely to impact her decisions on these kinds of constitutional issues, or any others that you'd rather talk about. That's fine. I don't.
That's fine. And I do think actually that the issues you listed are ones where she may have a significant role to play. On the abortion issue, it's fairly easy for an originalist to say that the Constitution itself has nothing to say about abortion. It has nothing to say about privacy, on which that depends, and rather those are exactly the sort of living Constitution ideas that contaminated the court's thinking 30 years ago, and therefore I could very much see Justice Barrett either preserving the fig leaf that we're going to keep Roe and Casey, but really making the undue burden standard so high that a state would be able to do almost whatever it wanted, or for her to go further and to say that Casey and Roe as well were wrongly decided. And so I do think those cases are vulnerable, as they have been for many years. And the challenge that she's going to face in doing that is to come up with a theory under which Roe and Casey die, but cases such as Griswold or older cases such as Pierce survive. Because if you're taking sort of a strict view of, well, I don't see it in my copy of the Constitution, there's an awful lot of rights that people think we have that you don't exactly see directly in the Constitution. So I do see her having an impact on abortion, and I think that depending on when that case gets to the Supreme Court, right, because we are not done with this whole issue where we may have court packing, we may have other changes, but I think that is an area where people can either be happy or very concerned, but I think she's going to have an effect. Guns, another area. You have not had the votes in the past to grant cert on a number of Second Amendment cases, including California's magazine restrictions and other restrictions that various states have tried to impose, even in a post-Chicago versus McDonald world. It wouldn't surprise me that as an originalist, Justice Barrett might have some views on the contents of the Second Amendment, and at least might think that those cases were worth hearing. And so I would not be surprised to see a good amount of Second Amendment litigation. And finally, religion, it's on the agenda already. There is an extremely important case coming before the court very soon, Fulton versus Philadelphia, regarding the ability of states to limit, it's a complicated issue statement, the ability of states to limit foster care agencies like the Catholic group from saying we don't want to have gay couples fostering children. And so that case, one of the questions presented, as I understand it, is whether the old Employment Division versus Smith test should be reconsidered, modified. That's a huge deal. And so I don't know where Professor Barrett comes out on that. We have a conflict between stare decisis, but Employment Division versus Smith itself disregarded stare decisis. So I could see her having a number of effects. One thing I will say where I don't think she'll have an effect, just to get this in, is I don't think she will affect the outcome of the California versus Texas lawsuit over the Affordable Care Act. I think I know how that case is coming out, and I don't think she's going to change it.
Professor Blackman, what about your views on how she'll affect these issues that were listed?
For the last 2 years or so, Chief Justice Roberts has been at the zenith of power. He was both the Chief Justice and the swing vote. Right? Since Kennedy retired, he was the end-all, be-all. No more. The chief can no longer control the agenda of the court. I think that's an important element. John Roberts does not like to be minimized, right? I don't see him being in dissent for the rest of his career. Seth, correct me if I'm wrong, but I can't think of any Chief Justice who was always in dissent. Chiefs always found a way to be in the majority. That's something they just historically have always done. I can't think of a good contrary example. Roberts will find a way to be in the majority, and he'll wield his power of assignment very persuasively. So if the court starts granting certiorari in more gun cases and more religion cases, and there are 5 votes to rule on the conservative side, I think Roberts will find a way to be in the majority in all of them and write the majority opinions to preserve his own ego and whatever else he's trying to do. I said that out loud. The key point, though, is if Roberts tries to go too moderate, he can lose the wolf pack, so to speak. He can lose the rest of them, and they can fracture off and make a concurrent judgment. And that's a very powerful tool. And I think that will force Roberts to the right. And that happens at the exact moment that, we have an election, in 4 days, 5 days? I've lost count. Where we could very likely be looking at, instead of 9, having 11. So this might just be a really awesome, 6 months where the conservatives have a majority, and come next fall we have 11 justices. So we're talking a very short horizon. But I think Justice Barrett's mere presence will turn a moderate 5-4 court to a far more conservative 6-3 court. Roberts will do everything he can to kick and scream, but at the end of the day, I think he'll come around and he'll try and always write the majority opinion. So,
and I think, Josh, you wouldn't rule out the possibility that you could have an even more conservative court were Trump to prevail.
Oh yeah, I mean, look, Justice Breyer's in his 80s. You know, right. Justice Sotomayor is, I guess, high 60s, low 70s. You know, it's not inconceivable he has one and maybe two more nominees if he wins re-election. In which case, basically, Kate will be by herself, which is, you know, kind of a stunning thought. You know, for all the veneration of Justice Ginsburg, had she retired in 2009 or 10, when the Democrats had almost 60 senators, we wouldn't be having this conversation. You know, people were very critical of RBG back in 2009, 2010. You had Souter step down right away. You had Stevens step down right away. If Kagan had stepped down as well, they could have confirmed just about anyone to replace her, who had been maybe 30 years younger.
True. That's a really interesting point you raised about Roberts with so many originalists by his side. That will be intriguing to see how that comes out. I'd like to ask Professor Blackman to follow up with one point that Professor Chandler made on employment division versus Smith, because I do think I agree with Professor Chandler that this is important. And the other thing that about Smith that I find interesting here is that there are originalist academics who have been fairly critical of employment division versus Smith because it did not do a thorough originalist job within the opinions rationale itself, notwithstanding that Scalia wrote it. So Professor Blackman, specifically on the free exercise clause, do you have any thoughts about what you think we might expect?
All right, so let me give more background on Smith, because I think Seth alluded to it a few minutes ago. In the 1960s, the Supreme Court had a series of cases involving free exercise of religion. One was called Sherbert against Werner, another called Wisconsin against Yoder. And these were cases where the state was imposing certain penalties on people because of their religious beliefs. Now, they weren't necessarily targeting these people of faith, but the consequence of their policies was to punish people who did exercise their faith. So in one case, you had an Amish family that didn't want to send their kid to school, and they were violating a compulsory education law. In another case, you had a person who was a Seventh-day Adventist who refused to work on the Sabbath, which for her was a Saturday, and this person was denied unemployment benefits. And in both cases, the court said, well, when you have laws that burden religion, even if they're neutral laws, you review those laws with a strict scrutiny framework. And in both cases, the court ruled in favor of the believer. These cases proved to be controversial because it allowed courts to second-guess the policies of the state. And this backlash built up to the 90 or 91 decision of employment division against Smith. This case involved a Native American who lost his job in part because he was using peyote, which was a controlled substance, but one used for Native American sacraments. Smith applied for unemployment compensation. He was denied because of his drug use. The Supreme Court didn't quite overrule Sherbert. They distinguished it in ways that I've never found quite persuasive. Seth is laughing.
Nobody understands how they...
Yeah, I mean, they said, well, here we have a criminal prohibition because drugs are illegal versus worshiping on the Sabbath. I mean, I can give you what the Scalia distinction is. I don't think it's very good. But they more or less overruled the Sherbert case. And this was a case that, the conservatives were in favor of. And you had the liberals like Justice Brennan and Justice Blackman were in dissent who were saying, we can't have this. Congress tried to perhaps respond to the Smith case with the Religious Freedom Restoration Act, which would have restored a strict scrutiny standard to free exercise cases. And then the court said, no, you can't do that. The RFRA statute cannot be applied to the states. That's beyond Congress's power. We decide what the Constitution means, not the Supreme Court, not Congress. But over the last, 25 years, the right has become very, very critical of Smith, and the left has sort of gravitated around it. It's almost been its reversal. And what we've seen is majority faiths, Christian faiths, are starting to say, wait a minute, we're being targeted, right? We need these protections. We don't worry about these Indians and these Amish. Forget about them. This is coming after us. We have to buy birth control for our insurance plans, and we have to give foster children to gay parents. Whoa, back off here, progressive state. So we've had this almost full reversal. Justice Thomas and a few others have signaled they'd be willing to reverse Smith, even though Thomas supported Smith in the past. All right, so there's a long wind-up to your question. If the court overrules Smith in the Fulton case that Professor Chandler mentioned earlier, that would radically alter free exercise case law nationwide. And to give you an easy example, we have all these COVID cases where these churches are saying you're treating us worse. Under Smith, these cases have been losers. If Smith is reversed and we have now strict scrutiny, I think these COVID cases come out differently. And by the way, I'm actually litigating one of these COVID cases on behalf of a Jewish school in New York. I sued Governor Cuomo, and I recognize that Smith makes my case harder. That's probably the most immediate aspect. The gay rights and the foster issue, is sort of a kind of like a canary in the coal mine, but this would permeate much more broadly. I don't know where ACB comes out. I'm sorry. I don't know where ACB comes out in this one. I'm not sure, but I think Smith is not long for this world.
So, Professor Chandler, there are really a couple ways you could follow up on this. One is if you wanted to elaborate any more on the Smith discussion. The other way is if you wanted to comment on the interesting observation that Justice Roberts may actually join the more conservative wing now. Did you want to comment on either one of them?
No, I don't really have any strong views on where Roberts is heading. I always feel like I sort of understand Chief Justice Roberts. Like I kind of get him. So I don't know. Having said that, I really don't know where he's going. Don't have any strong views.
Okay. Well, since you had a very brief follow-up, I'll ask you the next question. What about on matters, we talked about originalism and interpreting the constitutional text. What about on matters of interpreting a statutory text, the textualism that we could expect of Justice Barrett, and how that might affect any particular interpretation of a statute out there that you think is worthy of comment?
Right. So, you've got Chevron, right? You've got Chevron versus Nrdc, which is probably the most important statutory case that's been decided in the past 50 years or so, I would say, because it's sort of a meta rule about who has the power to interpret statutes. And depending on which party's ox is being gored at the particular time, there have been calls for overturning Chevron, which grants deference to the administrative agency, basically to the executive branch, vis-a-vis the courts. And so one could imagine, and there have been various calls for Chevron to be limited, overturned, and the court is fiddled with it at the margins. But I could certainly see that being revisited. I could see an originalist having great discomfort with the growth of the administrative state, which, it's hard to tease that out of the Constitution. We've grown accustomed to it since the New Deal and beyond, but I think Thomas Jefferson and those folks would be rather shocked to see what's happened. So I could see some statutory a change in statutory interpretation. I don't have a real strong view of where Justice Barrett stands on this. What I would say is, if she believes in stare decisis, Congress has had, whatever it is, 40 years to change the Chevron rule. That is, I believe Congress could overturn the Chevron rule if it wanted to do so, and it hasn't done that. And so that may be some indication that Chevron should stand until Congress is willing to change that rule or someone wants to pass a constitutional amendment on the subject.
Okay, so this is an interesting discussion now that Professor Chandler is raising, because he's taking my question in multiple directions, Professor Blackman. So, one question I had was just in general, what could we expect of the textualism of Professor Barrett? But Professor Chandler has opened up the role of the court in the administrative state and Chevron deference, and even opened up the non-delegation doctrine. So I don't know how many worms in this can you want to address.
It's a big can.
But,
it's a big can.
Is yours.
It's a big can. It's a very big can. Let me try this a different way. It seems that a person's perspective on administrative law often coincides with who has the White House. When you have a Democratic-controlled White House, progressives tend to favor deference, and they oppose the judiciary intervening. And when you have a Republican-controlled White House, conservatives prefer deference to the agencies, and they oppose courts intervening. Let's look at nationwide injunctions, our favorite remedy in the world, right? In the last couple of years of the Obama administration, you had federal judges in Texas handing out nationwide injunctions like Halloween candy. It was a very common affair. Now in the first 2 weeks of the Trump administration, we had like 1,000 nationwide injunctions on the travel ban. So look, where you sit depends on where you stand. Or something like that, right? People tend to sort of do this waltz every 4 to 8 years where they sort of switch positions. So if Biden wins, I fully expect, the conservatives to perhaps be a little more hostile about Chevron. So there's always a risk if the court kills Chevron, then they can't use it to restrict some future president they disagree with. Or if they say, no, we have to be deferential. We're not deferential, right? It cuts both ways. I've never gotten the obsession over Chevron. I know it's really important to people. No matter what the Supreme Court does, the lower court's still going to defer, right? Because the lower court's like, screw this. I don't know, about this expertise issue. I'm going to defer. And even if they're not using Chevron, they'll use Chevron, right? They'll call it something else. Say, well, we're going to do a hard look, but this is still okay. So I've never, I get why people oppose Chevron. Justice Thomas thinks it's unconstitutional. It's a violation of the separation of powers. I mean, okay, fine. But, I don't see that as the brass bullet. The bigger issue that Professor Chandler mentions, non-delegation. This is, I think, there's juice here. That's JUICE. There's some juice here. The reason why is that this can be used to take a hatchet to portions of the administrative state that people thought were fairly well established. I don't expect the court to go full 1936 and just start, declaring entire agencies invalid. But what the court could say is, well, we don't think Congress wants to give this much power to the agency, so we'll read the delegation more narrowly. This is a major question which we're not going to resolve. That's where I think the impact will be felt. So I'm not terribly concerned about administration doctrines, but I think the delegation doctrine is something to keep your eye on. It's a huge debate now among academics.
So specifically,
but can I add one other thing? If I could, it's not in response to either your question or Professor Blackman's answer, but I want to get it on the table anyway, which is contracts clause. COVID has raised massive contracts issues. So the CDC declaring that it's more difficult to evict someone. That raises both, administrative law issues, delegation issues, and contracts clause issues. And I could see a more conservative court having some doubts about the extreme measures that are being taken to intervene with various contracts in response to COVID. So I just wanted to throw that out there as one more thing on the table.
Do you have a view on that, Professor Blackman?
Not really. I think I'll give a general thought on COVID in general. Our legal system wasn't designed to deal with these sorts of pandemics where everything gets thrown up. Look, we're sitting here with a Zoom with 49 grids. I mean, this is our life. So my sincere hope is that whatever law is made during this period has a very short shelf life, and that, when we eventually go back to a normalcy, whatever that is, the precedents set here don't linger, because I think a lot of really bad laws have been made in the last few months. And I don't envy the courts trying to pick up the pieces when they figure out how to fix things.
Okay, we've got only actually a little less than 7 minutes. So I'm going to ask each of you to limit your response to no more than 3 minutes to this question. I understand that you each were somewhat intrigued about talking about the Ginsberg Role and how nominees have become accustomed to not discussing, how they're likely to rule on certain issues in the nominations process. So I'm going to leave this as an open-ended question. It's obviously not a rule. It's a pattern of behavior. But what do you think of it? Professor Blackman, 3 minutes, and then Professor Chandler.
Sure. So the Ginsberg Rule, if you're not familiar, during Justice Ginsburg's hearing more than 30 years ago, she was asked questions about how she might vote in a given case. And she said, I'm paraphrasing, I can't give any hints, I can't give any previews. And the thinking behind that is, if a judge tells you how they're going to vote on a case, they have to recuse, right? So in order to preserve a judge's neutrality, they won't tell you what they think. Of course, the reason why you pick them is because you want to know what they think. So there's this bizarre dance where the most important question is the question they will not answer. I think Ginsburg was the first to articulate this, and every nominee has sort of leveled up, so to speak. They've amplified what their predecessor has done. I'll be honest, the nominees are so much smarter than the senators can't pin them down. And I don't say this, some of the senators are Supreme Court clerks. I don't want to be too dismissive, but for the most part, the nominees are very sharp and they can evade questions well. I think the best reflection of a judge is what they've written before they came on the bench, which is why Judge Barrett was a law professor for 2 decades. I can read her stuff and get a pretty good sense of where she is. Right, she's not a cipher. She's not this empty vessel like John Roberts was. We have no idea what the hell he thinks. Right, we have a record with her. She was a federal judge for not very long, 3 years. So I'm not concerned that she won't tell me what she'll do. I think her background tells us far more than what some questions at the hearing would reveal. Okay,
Professor Chandler.
Yeah, I just think the Ginsberg Rule, which has been taken now to extremes, is an inappropriate shield that the nominees are using to prevent any sort of discussion. They've been picked because at least, out of hundreds of qualified people, because the president believes that they have certain predispositions which will make them vote in ways that they like. And neither Trump nor Obama nor anyone else is particularly hiding that fact, okay? And so, yes, of course, they can't say exactly how a particular case would come out. And Justice Barrett was correct to say, I need to read the briefs and I need to see the particular context. But nonetheless, there is a level of candor that's absent when they pretend that they have absolutely no predisposition on the matter. I don't believe that. I don't think any of the senators believe that, and I doubt they believe that either. And so it leads to a particularly inane confirmation process, of which I would say both parties were equally guilty this time around, in which phony issues are raised or non-issues. Or they talk about whether she likes to bake brownies or whatever question that was. And so I think we are entitled to know a little bit more about the predispositions of the nominees. I don't think it would force them to recuse. Obviously, they would keep an open mind. But, just as I'm giving my opinions here, I would be subject to revising them in a particular case. I think they can do the same thing.
Okay, 1 minute each, starting with Professor Blackman. If there is a controversy involving the election, ballots, timing, anything that affects the outcome of the election, do you think that, not because she is required to, but just as a matter of ethics, do you think that Justice Barrett, as some have argued, should recuse herself? 1 minute.
Is there an election coming up? I missed that one. No. I think it's a tough call. I think it's a close call. I think you can go either way. I don't think there's any requirement to. I don't think there's even any rule to. I can see why she would. I can also see why she wouldn't. If I had to guess, I think she's in for it. There was an election case decided yesterday or the day before, and she didn't participate, but her press statement was, "I'm not yet up to speed," which signals in my mind that she will be up to speed next go round.
Okay. What about you, Professor Chandler? Do you think she should recuse?
I think if she feels biased, she should recuse, but I don't think she's obligated to, because that's essentially an admission that she is a Trump toady. And while conceivably that could be true, I don't think one should necessarily presume that. And so it gave me some hope that she chose not to participate in the case, which was immediately before them. But we are going to see a cascade of these election cases. I hope that they don't matter in the ultimate result. But I guess I disagree with one of my colleagues who wrote a learned op-ed saying that she's obliged to recuse.
Okay. We really only have, I believe, 1 minute. And is there anyone that has a question? I doubt anyone has a question that could be answered in 1 minute by two panelists. So I think that the appropriate course of action is to thank Professor Blackman and to thank Professor Chandler with a showing of hand clapping and to wish you well for the rest of the day.
Thank you all so much. Thank you, Professor Chandler. Thank you, Professor Buckles. Take care.
Bye, guys.
Thank you all for coming.
Thank you.